Good afternoon. Everyone has entered the webinar as a mute attendee, but Zoom features include a Q&A tab where you can ask any questions during the program. We'll collect them all and answer either live during the webinar or afterward by email. Also, you can click and drag the boundaries between the windows to adjust the size of the slides of the presenters. And now, after a brief introduction, we'll proceed with today's webinar. As always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution. Now, Rod, go ahead, please.
Sure. Nice to be with all of you, and really look forward to this hour framework within which we're going to be talking about a very complex area of the law, an area of the law, aviation, in which is really a national practice for those that engage it, and deals a lot with not only catastrophic injuries, death, but also very complex mechanical issues of that which keeps aircraft in the air. And with that, we really have a distinguished panel here. I'm grateful for their taking the time to be a part of it. And that's Jamie Lebovitz with the Nuremberg Paris law firm out of Cleveland, Ohio, on behalf of the plaintiff side of things. Mike McQuillen with Henshaw Culberson out of Chicago, who typically handles the defense side. I've got Brad Hassell, a member of the Upchurch, Watson, White, and Max firm, who has not only mediated but has litigated numerous of these cases in the state of Florida and beyond. So with that, what I'd like to do is give each one of them a chance to introduce themselves, and then we'll go into the topics. Jamie?
Good morning, everyone. As Rod indicated, my name is Jamie Lebovitz. I'm a senior partner at the Nuremberg Paris law firm. We're based in Cleveland. I've been practicing primarily air crash litigation and trial work for over 40 years in commercial aviation cases, general aviation, helicopters, and also matters involving air traffic control, which is FAA. I look forward to presenting to you this morning the plaintiff's perspective on mediating an aviation case. It's an important phase in connection with all types of aviation cases, and more often than not, mediation with the proper mediator and experienced counsel, there is a very high probability that cases can resolve at that stage. So again, thank you for your attendance this morning, and we'll talk with you more soon.
Great. Mike, on behalf of the defense.
Thanks, Rod. Thanks, Jamie. Thanks, everyone, for attending. My name is Mike McQuillen from as Rod mentioned, the Henshaw Culberson firm, Chicago, Illinois. Where I'm the practice group leader for the aviation section. We have a terrific team of lawyers who almost exclusively defend product manufacturers, airlines, air traffic control facilities, and a variety of operators and other aviation entities. We've been doing for many years, me personally, like Jamie, over 40 years now, and look forward to talking to you today about working through the mediation process.
Great, Mike. Thank you very much. Brad?
Yes, good morning, everyone. Happy to be here. I'm very pleased to have been mediating with Rod's group for a little over a year and a half now, but I'm coming off about 45 years as a trial lawyer, the large part of which was aviation cases representing airlines, operators, large and small, component part manufacturers, maintainers, and individual pilots on all types of cases. Like Jamie, I've become involved in some air traffic control litigation over the years. And I'm transitioned over the last year or so into mediation because I think there's a place in these cases for a good discussion and mediated result. So I'm happy to be here and appreciate the opportunity to speak with you all this morning.
Well, Brad, thank you very much. And we've got um, a list of 10 items that we think are really critical to the successful mediation and opportunity of resolution. You know, mediation is not on the clock. It's something that it's a process. It's a process that's got to, start with your preparation and getting to the table, working through, getting to selecting the mediator, and then the negotiation with the concept of really there's no need to quit until you've exhausted every source. But it begins with an understanding of the technical landscape. And I'd like both Jamie and Mike and Brad to address the idea of how you get familiar with the aircraft operations, the maintenance, the regulatory frameworks, as well as the credibility that helps you bridge the gap, not only of the gap of negotiation, but the gap of knowledge. Jamie?
Yes. So depends, of course, on what type of air crash case you're dealing with, whether it's commercial aviation, general aviation. If you're dealing with an air traffic control matter, there are a number of different issues that one must identify and become familiar with. And as I have seen over the course of my career, there's generally more than one cause that brings an airplane down and creates, horrible losses. More often than not, loss of life. But there are situations where people do survive. And so, what I would suggest is familiarizing yourself with the federal aviation regulations. That's what I would call the Bible, that are regulations that are promulgated, by the FAA. And there's various subsets of regulations. There's what's called Part 91, which apply to all aviation operations. And then there are other parts, such as Part 135, which are oftentimes, applicable to charter operations or operations where somebody, you know, hires pilots to fly them for, and there's revenue involved. And then there's Part 121, which is typically for commercial aviation operations. So I think an understanding of the regulations is very, very important. Um, and so that's number one. Number two, if you're dealing with a matter that involves air traffic control, you can sue. You can actually sue the United States government. You don't sue the FAA. It's not a party per se, but the United States is. And you have to go through a process in filing what's called a Form 95 and allow a certain period of time to elapse to see whether or not the government's going to accept liability. If they don't, then you can actually file a civil suit. So you should be familiar with Form 95, and then you should familiarize yourself with what's called the 7110.65 regulations, which really govern how air traffic control operations work. And what is the responsibilities of air traffic control operators, whether in the tower, whether approach, departure control, etc. So those are really, really important to get a handle on. Then you get into situations where, as I said before, there are usually multiplicity of causes that bring an airplane down. It could be a maintenance issue. It could be, an engine that was not taken care of properly. May have been built perfectly, and but engines, whether in an airplane or a car, they have to be maintained properly. And every engine manufacturer puts out a manual that governs how an engine has to be maintained in order for it to be what's called airworthy and safe for flight. Um, other documents that must be, considered in any aviation case would be logbooks. Logbooks of the pilot. Was the pilot qualified? Was the pilot current? Did he have a current medical? Look at the airframe logbook. which concerns the entirety of the airframe itself, all of the systems and appliances in connection with the airframe. And then there are other logbooks for the engines. And then if it's a turboprop or a piston-driven aircraft, then there's engine logbooks and there's propeller logbooks. So there's quite a bit of material that has to be considered and carefully reviewed, not only by the lawyer, but by the experts that the lawyers bring in to consult with and to retain to potentially testify at trial. So um, we could do a much deeper dive in that, but time is of the essence here. And I just wanted to give you just a general overview of some of the things that need to be considered and that you have to become familiar with.
Thanks, Jamie. Appreciate that. Mike?
Yeah, Jamie did a great job hitting most of the major points. And it does depend on what your case is about. For example, if you do have a products case, you obviously need to check the regulations to find out, what governs your product. For example, if it's an engine, as Jamie noted, there are specific sections of the regulations that, Part 23 for normal category aircraft, other parts for engines itself that talk about how they need to be designed. I think, Part 33 talks a lot about engines as well. And it is important to understand what regs apply to the design. If you're looking at an airframe itself, there are sections that talk about the airframe itself, the standards to which it needs to be designed. If you're in a case for an airline, of course, there are specific parts under Part 121. If you're a commercial, air transport operator, Part 135, some of your more charter operations have specific requirements in there on both the operations side, particularly with respect to the training of pilots, and both of them also have sections on how the airplanes are to be maintained. So there's just a wealth of information that's in there if you do have one of these cases, to make sure you understand what applies to your issue. A lot of times too, in addition to what Jamie said, he mentioned whether it's air traffic control or the other things. We also, in addition to wanting to know about what the product did or what the airline did, particularly in the products world, almost every case that we see, there's usually the pilot's conduct is going to be at least looked into. It doesn't mean they're always going to be doing something wrong, but it is something much like the health of the airplane or the engine. We look at the health of the pilot too. So it's important to understand the pilot's background, what the specific regulations are, many found in Part 91, about what regulations apply to the pilot. Were they current? Did they have the instrument experience that they were supposed to have? There's a wealth of rules that apply to those aspects too. So those are important to understand to make sure the pilot was compliant not only with the certification requirements to validly and legally operate the aircraft, but the medical regulations too. There are certain medical requirements for pilots that people need to look into. Also, another aspect is the weather. Many of the cases that we have happen in areas of weather. Not all of them, but some do. It's important to get a good grip on what the weather is. There's requirements for forecasting, what the pilots are supposed to be familiar with. There are many tools available to pilots, how they get their pre-flight briefings, en route briefings, and then working with the meteorologist to understand what the weather patterns really were and whether it had any effect, and whether the pilot was sufficiently rated to fly in those conditions. So on top of everything Jamie said about the regulations that apply to the design of aircraft, the design of engines, and the operation of a commercial airline or charter airline, clearly the piloting, whether are other facets that need to be looked into too. The only last thing I'd touch upon on the technical aspect, of course, is in the event you have military accidents. We've obviously had a few of those as well, and there is a whole other scheme that applies to some accidents involving military aircraft. So all those things need to be taken into consideration.
Mike, thank you for that. Very thorough with.
Rod, if I could add one more
Sure.
point on the technical, just give me 30 seconds.
Sure.
Many aircraft, particularly all commercial aviation aircraft, have what you've heard the terms black boxes. The black box is, technically a flight data recorder, which documents scores of information about the airplane, the how the engine's operating, what the settings of the flaps are, and speed, altitude, just a whole series of data points that are very, very important in reconstructing what happened. And likewise, there's the cockpit voice recorder required in all Part 121 aircraft. Many other aircraft do have CVRs as well, and those capture the communications by and between the crew, as well as the communications with air traffic control. Even the smaller aircraft, general aviation aircraft, they may not have the typical black box that would be found in a commercial aviation aircraft, but they do have devices that contain non-volatile data, which could provide a lot of useful information about how the engine has been operating on the day of the event, but also historically to see if there's any kind of pattern of problems that should have been identified to troubleshoot and remedy what would ultimately be and prevent what ultimately would have been, a loss of the airplane, a loss of life. So those are other things that you should be very well aware of.
Thanks for mentioning those, Jamie. Appreciate that. With that, Brad, your thoughts?
Yeah, thank you. To expand a little bit on what Jamie just said, when I started and when these guys started as well, a lot of this information we had to derive by looking at radar data and so forth. These days, with ADS-B radar data, weather data that's available to everyone with a computer, you get incredibly granular information of what happened almost at every second of the flight. And it's very, very important that you and your experts know about that. This is one of the most heavily regulated areas that we will ever deal with as lawyers. For example, if a pilot to get a pilot certificate, there is an incredible amount of regulations the pilot has to memorize and be tested on, both in a written test and in an oral test with typically an FAA examiner. I just happen to have with me, this is an older version of a regulation book that a young pilot would use to study just to get the license. And you see it's about 1,000 pages of very small government print. And that's just the tip of the iceberg. And the folks in the industry live and breathe these regulations. It's the air that they breathe. It's the water that they swim in, and a lot of these things they take for granted. And to deal with these topics, you're going to have to know them as well. If we go to try an automobile case and we walk into the courtroom, everybody in that courtroom is going to have some degree of expertise in operating a motor vehicle. There's a lot of things we can take for granted. We don't have to teach people how the steering wheel or the brakes work. But in an aviation case, typically you'll have no one on your jury that understands or is familiar with any of these areas. So when we go to court, we're starting from scratch. Typically, your judge won't have any familiarity with that either. And in addition to these regulations, there are federal and state statutes that lay over the top of them and govern the assessment of liability and the distribution of liability, and sometimes limitations and capping of damages that we all have to be familiar with. Why is that important in the mediation context? It's because as we approach a negotiation of our case, we're trying to make predictions as to what will happen in court. And in order to do that, we have to know the regulatory and the statutory background, as well as the nuts and bolts of the aircraft operation that a jury will be asked to decide as more or less strangers to this world, and predict what will happen and assess our risk accordingly. And so that's why our initial topic here, our initial point, is to begin by understanding the technical landscape. And I can't stress that enough.
Well stated, Brad. And certainly a perspective has got to be taken in consideration, those who are going to make the decision ultimately. With that, of course, the next phase of this is picking the right mediator. This isn't just knowing the process, it's knowing the area, the experience with this kind of litigation, and knowledge of the jargon and the standards involved. Mike, would you like to speak with that aspect of it, choosing the mediator?
Sure, Rod. I'm happy to. So, you know, it, the topic you just covered is a really good segue into this because we just talked about how important it is for the lawyers to understand this information. But it's equally, if not more important, to have a mediator who understands it. They're not going to know every single reg. They're not going to know everything that applies to the case that we have, but they're going to know that there is a body of regulations that are out there. They will have likely dealt, with this type of occurrence before, and they're going to be able to speak the language. I mean, it's pretty important, I think, for the mediator to have, some knowledge of the technical aspects of the case with some kind of background. For example, our most of our clients, some have very specific views as to who they like to use. Many don't, and they're very deferential to us. And so we lawyers have an interest in making sure we have the right person as well. If we were to pick someone who doesn't have that knowledge or doesn't regularly swim in the water, as Brad would say, we risk wasting our clients' time too by taking the time to educate somebody, that someone should at least have a baseline with. So we do have an interest in making sure we have someone that does have some experience in aviation law and complex litigation, particularly if it's a complex product liability case where you can have a multitude of all the areas everyone's already touched upon. So, we just don't want to be in a position where you have to take an extreme amount of time just to get the mediator up to speed on what the technical terms are. So we have that interest in making sure we have someone who speaks the language before we go in it to help us kind of weave through that tangled web of regulations. So that's really the best thing I can say is we want someone who really understands the speak and understands that there are standards and the importance of complying with those standards. So I think it is important to have a mediator with that background.
Well, good, Mike. Thank you very much. Jamie, your thoughts on that?
Mike covered it very, very comprehensively. And so there's very little more that I could add. But one point that I do want to emphasize is that I think it's important when choosing the mediator for your case is that you have spoken with other people if you haven't used this particular mediator before, and make certain, be confident that the mediator is someone who's going to very carefully and thoroughly study the materials that you provide in advance of the mediation, so that you don't take the time at the mediation to educate the mediator. You want to make sure that the mediator is well educated and familiar with your case strengths and weaknesses, whatever they may be, beforehand.
Very good, Jamie. I think those points are well taken. Brad, your thoughts with regard to selections of mediator?
It's been very well covered, but let me just add one thing. One of the things we try to do in mediation is identify issues and take a reasoned approach to them and also communicate between the sides as far as the strengths and weaknesses of positions. And it's very, very difficult to do that if you don't understand the framework, the regulations, and the statutes. It's if, for example, Mike explains to me his defense based on a particular regulation, and I don't understand the regulation, it's very difficult for me to talk to Jamie about it, or even to communicate what the issue may be. And so that I think, and I would echo what Mike and Jamie have said, it's very important to have someone that knows that area. And I would also echo what Jamie said the pre-mediation preparation, which I think we're going to cover in a minute, is very important because these are cases with a lot of detail. Small facts make a big difference, and everybody needs to be proficient in those as we engage in a discussion of the case.
Right, Rod. I would say one other thing too, Rod.
Go ahead, Mike. Go right ahead.
On that note, I agree with Brad 100%. I mean, one of the things too that we want to make sure that we have is another reason to make sure we have someone who at least is somewhat familiar with the aviation landscape is I have had some mediations in the past where we did not have a mediator that had that kind of an experience. And it's okay. You try to do what you can to educate them. Some can catch on okay, but some don't. And what I've seen is many times the mediator will shake their head and say, yeah, I understand this stuff. And immediately they'll shift away and just start talking about numbers. And it's because they don't either understand or they don't want to take the time to learn what the regulations are that apply, or what the technical aspects of the case are that we think both, I think Jamie would say, and from the defense, we would say that it's important, we believe, for the mediator to be able to effectively use those tools to go beat up on both of us, right? So I do think it's another reason why you like to have someone with some experience.
Well, and it's with that, I really do appreciate that because diving in, from the plaintiff's and defense side, you all have been, quote, living with this case for a while, and a mediator is going to get adopted to get into it and be a quick learn and study, regulatory wise, maintenance operation wise, mechanically. Brad, what are your thoughts in terms of the preparation? And I'm going to combine actually what we have, the thorough preparation with the client management of expectations, because both of those are items that go into the mediation. What is your take on that, Brad?
I agree. One is part of the other. And I'm a big proponent of pre-mediation mediation, if I can use that term, because the more we can do before the actual formal session starts, the less work we have to do when we get there. As everybody's noted, these are complex cases. They're not just factually and legally complex or procedurally complex sometimes. And we have to get familiar with the case file. Where are we in the case? What are the postures of the parties? What are the defenses that have been raised? And I like to talk to the parties ahead of time and figure out where the sticking points are. In that regard, do we have the right folks at the table? Are they aware? Are they prepared? Sometimes clients, particularly institutional clients, need time to react to new information. Do they have the information that they need? And do they have time to react? And then, Rod, building on your comment on client expectations, many times parties will come in, and I'm not talking about the lawyers here, but the individual parties, they don't have a lot of familiarity with the mediation process. They're not sure if it's a trial or an arbitration. They've got to be made familiar and comfortable with what the mediation process is going to be, and to treat it not as an ordeal, but as an opportunity to resolve their case, and if not, at least to learn where the pressure points are or where the differences are. As part of the pre-trial or pre-mediation, preparation, parties should be looking at their evaluations to have a good idea of what their chances are at trial, best case and worst case. And so there's a lot to be done, and I think a lot of it can be done before we actually, show up for the formal mediation conference.
Well, excellent. And with that, if you could address that, Jamie, from both the preparation as well as client expectations. I know representing plaintiffs as you do, they too are not familiar with all the intricacies, and that takes some work not only by you, but incorporating the mediator at times.
Thank you, Rod. One thing that I want to share is what we have found to be very helpful in managing client expectations, number one, and number two, getting a sense of how your case is going to unfold before a jury and how a jury would react, and that is doing a focus group. And these cases are very expensive. There's an investment of time and resources, and a focus group, even before mediation, could be very informative to the lawyers on both sides. And we've done it. You know, I don't know if Mike has. My sense is he has, because I know Mike's reputation, and those could be very, very helpful. And it may be something that, if done, the results of which can be shared with the mediator in educating the mediator. That's one point. Now, another is this: as the plaintiff's counsel, we're dealing with folks who have experienced an unexpected, unforeseeable loss, whether it's a husband, whether it's a child, whether it's a parent. It's bad no matter what. And mediation, yes, it's generally going to be quite a bit of time away from when the loss occurred, but folks don't necessarily get over it. They might, heal a little bit, but they never get over it. And a lot of this brings back, you know, everything that happened originally, because you're talking all over again about the event that occurred. So I think it's very important in managing the client's expectations to have the mediator, particularly with the plaintiff, meet with the plaintiff family members before the mediation actually takes place, so that the clients themselves could feel comfortable and at ease with the process, because they've never been through anything like this. Mike, myself, Rod, Brad, we've done this, but the plaintiffs, it's the one and only time, unless the case goes to trial, that they have to deal with this. So you got to try to put yourselves in their shoes, and managing them and keeping them, on a level, field, so to speak. The other thing too is, we talked about mediation briefs and expert reports. I haven't been involved in an aviation case where there aren't experts, whether it's pilot experts, whether it's accident reconstruction, aircraft design, maintenance folks. There's a whole litany of experts that, will be typically involved in a case. And it's important to have experts, because while we all have heard of the NTSB, which is the governmental agency that really takes control of the investigation from the very beginning, and they issue factual findings and they issue what's known as a probable cause report. There's limitations as to what the NTSB's work can do for you in your case. The probable cause report is not admissible, and oftentimes it gets it wrong, or doesn't even come up with a probable cause, when in fact there are causes, or many causes. So you've got to know and be familiar with what the NTSB's work can do for you and what the limitations are. And so that is important. The other thing is, in a mediation, I've been through a number of them where the insurance carrier has a claims representative or multiple representatives there, because there'll be multiple parties. And you want to make certain before you even get to the mediation, confirm with the mediator that there is going to be someone there with authority up to the settlement demand, because you don't want to go through the process and get to a point where the representative there doesn't have full authority, and they have to go back and they have to talk to a manager, they have to talk to a reinsurer, and that really undermines the whole process. You go through an entire mediation and then you hit a wall. not good. So those are the major points that I wanted to make on these particular subjects.
Jamie, thank you very much. I appreciate that. Mike, what are your thoughts with regard to the preparation and the client expectations going into it?
A couple things, Rod. I mean, let's talk about the first thing, and that's the preparation. I think everyone's hit on it so far, but I'll just kind of sum up. Um, if we were to hire Brad or Rod or someone, usually what we would do in something like that is we'd want to start by giving them the NTSB report, right? It's got some basic facts. Jamie's right. Probable cause is typically out, but there's no specific exclusion of some of the factual data. So, and regardless of admissibility, it's good background material that the mediator, we think, should start with. Secondly, I agree with Jamie. Experts are experts. We all deal with them. They're very much advocates for their clients, but if there are certain sections of an expert's testimony that you think is important, that the mediator should hear, those should be supplied. I'd be interested when I'm finished of hearing what Brad and Rod think when someone attaches 15 depositions to complete 300-page transcript for each. I think it's probably more helpful to be fairly surgical about if you think you got some good admissions from the other side to include those. I typically do not like to attach an entire dep transcript out of fear that no one's going to read the whole dang thing. So you try to be really focused on what you supply in terms of opinions that perhaps one of your did, but maybe more importantly, any admissions that you may have gotten from the other side, if any. And the third thing to, as far as preparation is concerned, is to really make sure you understand what law applies. In some of these airplane cases, there's constant battles over what law is going to apply. Is it the place of the accident? Is it where the plane was manufactured, where the airline was? I mean, there's just, and is there a difference between liability and for one state and if the passenger would lived in some other state other than where the accident happened, should we apply that state's damages law? Make sure you're armed with that because that's important in marketing too. Sometimes it hurts the defense, sometimes it's very helpful. Let's talk real quickly about the notion of things like coverage issues too. I think it's important, at least on the defense side, to know who else is there. Are you the only game in town? I think it's important when you do your preparation is to find out who your co-defendants are, whether you're adverse co-defendants, whether you're friendly co-defendants, and how much coverage do they have. It's important to know that because if the law imposes, for example, joint and several liability, I think that's something that you need to take into account as you're preparing for this thing to know how you're going to deal with that. Sometimes we find in representing a manufacturer, there's a maintenance facility that has maybe $100,000 per seat policy. Well, that's something that our clients need to understand, that we need to work through with the mediator. That can have a significant effect on the case. We also should talk about what should be shared and what shouldn't be shared. Many times I'll see a mediation statement and the initial draft is a very advocative piece, which is fine. We're lawyers, that's what we should do. But I'm kind of a fan of not being afraid to identify your warts. I think if all you do is give the mediator a very glowing pre-suit, perhaps confidential mediation statement, in theory, I believe you risk credibility if you haven't raised your weakness and the other side points it out first. So, I do think it's important to identify your warts if you're going to make it a confidential submission. And you should also talk about whether to share mediation statements beforehand. That's the whole topic of, managing client expectations. Do you want to share? We've had some times where I want to share the mediation statement with the other side. It depends a lot about how the facts have lined up. If there's certain things you want the other side to hear, you should consider sharing it. You can always submit something separate to the mediator that you might not want the other side to see just yet. That's another option that you have. So again, it goes into the topic of preparing, but also managing client expectations. Once you get to that mediation room, many times, we hear about opening statements. Not a fan of opening statements. I mean, I have sat in many mediations where the mediator has allowed those, and it's not good from sometimes both plaintiff and defense. Sometimes the lawyers, both the plaintiff's lawyers and the defense lawyers, are guilty of it too. Um, you're saying something or getting the client's expectations so fired up, you spend the first hour or two, sometimes three, just to try to get that kettle temp down of the plaintiffs that are at the mediation because they're so mad at the defense, or the plaintiff's lawyer has them so pumped up, or the client's expectations on the defense side are so low because the lawyer thinks he did a great job and hasn't evaluated the risk. So all those things need to be thoroughly discussed and managed as we move forward. The other thing that two last things. I agree with Jamie's point that, it's unfortunate in our business. I mean, Jamie, probably doesn't have many repeat clients for sad reasons on the plaintiff side. But on the defense side, we have many mediations where some of our clients are first timers too. The lawyers might not be. But I mediated a case 2 weeks ago with a client, a fairly well-known client who had never been through a mediation before. The insurance side did, but the insured did not. So there was a learning curve there too. So we do get those as well. But I do think it's important for when I know that Brad and Rod are going to be able to tell that family that, hey, look, these the people on the insurance side, they do this all the time. So if it comes off crass, this is what they do. And I know they do a great job managing those expectations. The last point I'd make is, in terms of managing client expectations, the one thing we like to see is a mediator and plaintiffs too, who allow. I'm a big fan of letting the mediator talk to our clients, but it should be mutual. We go through many mediations where sometimes the plaintiffs will come in and they say, we don't want that mediator talking to our clients. You talk to us and we'll filter it to them. We think that's completely unproductive. And the same cuts with us. We don't want to do that either. We want to make our clients available to the mediator, and we think it should work both ways because that's, after all, you want the clients to hear what an independent party thinks of your case. So it should be something both sides do. So I went on a while there, and I apologize, but those are my quick thoughts.
They're great thoughts, and also this is where there's the pre-mediation as well as the mediation, and it is up to the mediator to actively orchestrate convening with each of the attorneys and perhaps their clients, and at sometimes, especially when hearing things that could become a conflict, to try to manage them before the mediation. Hey, get the plaintiff's attorney and the defense attorney together in a call, in a Zoom, in an effort to say, let's work through this one issue before we get to the table, so as to keep that table viable for negotiations and not just the adversarial positions that drive us apart. But with that, and a little more mundane, are the jurisdictional and regulatory issues that we get confronted with. Mike, and then Jamie, would you like to address those? Your international treaties that do have a great impact on the evaluation of the case, as well as the federal regulations.
Sure, I know we're eating up some time here, so I'll try to be brief and quick. So jurisdiction is clearly something that every defense lawyer is going to look at, right? Was your client rightly sued in the forum that the plaintiffs chose? That's something that needs to be looked at. Yes, for on the airline side, and even on the product side, the Montreal Convention can have an effect on the case. Obviously, Montreal applies to more the airlines, not the product manufacturers, but if there's a product manufacturer in with the airline, it may affect that manufacturer's exposure and the airline's exposure as well, if there's others. So it is important to understand what the Montreal rules apply and how they will affect your case. I would add a couple other things on the manufacturer side. The General Aviation Revitalization Act is something that comes up in many of our cases. A lot of the airplanes flying under the Part 91 airplanes in particular, people flying under Part 91 and some of the smaller piston engine type airplanes that we see that unfortunately crash. Many of them are old, and many of them are over 18 years old that are flying. I saw some stats about how many of the fleet is more than 18 years old, and it's a very significant percentage of the planes still flying. So understanding how that potential statute of repose affects is a big deal. As I mentioned in the regulatory side, if there's a military accident, understanding the government contractor's defense and how that can apply is a big deal to weave through. So those are things that everyone needs to, clearly understand. So that's just a quick summary, but I'm sure Jamie and Brad have more.
Thanks, Mike. Appreciate that. Jamie?
Mike covered 99% of what I would have also covered, but let me just mention too that there are other jurisdictional and in legal frameworks that could potentially apply. You could find yourself in a situation where an airplane goes down in international waters. So you may have maritime law that would have to be looked at to see if it applies, and there's a whole body of law under maritime as far as what your available damages are and whether there are any caps. And there's also the Death on the High Seas Act, which is another, regulatory body of law that applies depending upon where an airplane goes down. If it goes down in international waters versus, waters that are territorial, that also implicates a whole different, framework of liability and damages issues that have to be considered. So it gets a little complicated and murky, but once you familiarize yourself with it and get some guidance from those who've had cases involving those different treaties and bodies of law, you can pretty much navigate your way through it. But this is it's not a very simple, plane goes down, boom. Um, you know, there's no uniform body of law, which I think has become pretty apparent from this discussion so far. So, just be aware of that. And fortunately, there's a lot of resource out there. A lot of the cases that come to me come from lawyers who do not do this type of work, and it's very foreign to them. And you know, lawyers like Mike and I and the others in this very niche area are very good resources because of the fact that we've crossed into so many of these different, jurisdictional and treaty and legal areas. So
It's interesting to segue from what you're saying, Jamie and Mike. We've had one of the participants in our webinar who've asked the question. I don't know if A, it's capable of being answered, but I'd like to give it a shot. What regulations do you think are applicable to the November 2026 UPS 1976 crash? I don't think it's November 2026, maybe 25, but the UPS crash, do you know what regulations would be applicable to that incident? Any of the three of you?
you're talking about the MD-11 that crashed just on takeoff from Louisville, Kentucky?
Well, I'm looking at this inquiry, and it talks about the UPS 2976 crash. I don't know if that's the one or not. Are there some regulations that are relevant to that incident? Does anybody know that?
Yeah, I mean,
We could spend the whole hour on those. I think that's the
Yeah.
one where the engine literally departed the aircraft on
Right.
takeoff.
Right.
They left it behind on the runway.
Uh-huh.
And
There's a
so
there's a lot of history there. There was something that occurred, a crash that occurred in outside of Chicago area airport. It was an American Airlines DC-10 where the engine pylon came off, and it was more of a maintenance issue. There's design issues. The regulations that Mike and I and everyone talked about early on, part 121, the federal aviation regulations, many of those would be implicated here. There's product liability issues. The airplane just came out of a maintenance shop in Texas, and So there are much of what we discussed would be applicable to this, and there's going to be choice of law issues as well. Plane goes down in Kentucky. You had pilots that were from other parts of the country, and you had people who were killed, or you had people who survived, people that just had emotional injuries, others that had physical. This is that case in and of itself would probably, be a good example of maybe a 2-3 hour seminar where we can cover
Yeah.
a lot of things.
Sure, sure. Brad, can you
Sorry to
speak to the?
interrupt. We have 10 minutes remaining. Just wanted to tell you.
Okay.
Thank you. Brad, can you speak to the valuation strategies that go into this?
Yeah, I can. And this touches on the point that a couple of us have made already, and that's the choice of law. And these cases are complex, and sometimes there's a lot of defendants. Sometimes the defendants can't all be sued in the same court or the same venue because they don't have minimum contacts and so forth. So you may end up with a few parallel cases pending, and there's always the tension in these: what law applies, which state. It's not necessarily where the crash happened. It's not necessarily where the aircraft took off. And so there's a whole body of law, which we don't have time to get into today on that. But each different jurisdiction may have a little bit approach as to damages. And one of the things that I think we need to do as we approach mediation is to wrestle that issue to the ground and decide which states or law applies. What does that state provide with respect to what damages are claimable and awardable? How are those calculated? What elements are includable? Are there caps on those? Are there limitations on those? And so, again, we don't have time to go into all of the nuances of that, but I want to point out that that's an issue that anybody proceeding to a negotiation on one of these cases needs to consider.
Jamie, any thoughts with regard to that evaluation strategy and the various elements of damages and ways of structuring settlements?
Well, pre-mediation mediation should be the forum where there is an understanding of where everyone is coming from on what body of law is going to apply on measuring damages. Okay, because if the defendant is coming from one, place and the plaintiff from another, and there's not a meeting of the minds, whether it's Ohio law or Florida law or some other state, that can make or break a mediation. So, that should be something that is fully addressed in a pre-mediation before walking into the mediation itself. Because, there are states that limit damages. There's some states that don't have non-economic damages, just pecuniary damages. There's some states where you can recover for pre-death pain and suffering before the plane actually comes to final rest, and people suffer emotional fright and terror and maybe physical injuries. So those are things that need to be worked out and will have a direct influence on what the recovery is going to be. So I think that, generally, again, this is you could spend a lot of time just talking about damages, but that is something that should be worked out before the mediation.
Well, I absolutely. If you come in with different perspectives, you're not going to get anywhere. Mike, your thoughts on that? And we have one question that came up in the midst of that, and that is, have you mediated or been involved where an amendment to a non-commercial aircraft flight manual in the last 5 years regarding the addition of a new part, de-icing system, circumvents the federal 18-year statute of repose, since the AFM is part under the FAA regulations in a products case involving failure of duty to warn? Kind of a convoluted question, but if you can grab a part of that, maybe good to address it to one of our participants.
Since Mike is next at bat, I'll let him take that.
I think Jamie's just successfully punted. I could certainly take a shot. I think
Sure.
what the questioner is asking is if there's a is the flight manual, if there's an amendment to the flight manual, is that considered, for example, a modification that gets around the 18-year statute of the replacement part exception? And all I would say is there is case law that addresses that specific issue. I might want to take a look at. I know it's been addressed in a couple of different cases.
If there's
Very
a new
good.
part, also, one of the exceptions to GARA is, let's say you have an airplane that is over 18 years of age, but there is a new component, whether it's a de-icing boot. Let's talk about that. On certain aircraft, they're de-icing boots, and it was a failure of this newly installed new product, less than 18 years of age, that failed and was a direct cause of the airplane, coming down. Uh, that new part would start a new clock, a new 18-year statute of repose. That's my understanding. I don't know if Mike has a different view, but if that part is in fact implicated in the loss of the airplane.
Yeah, I think your latter comments is the key point. I agree that if you put on a new part within that 18-year period, that may be the replacement part exception, but I also think the statute requires it to be causative.
Yep.
Yeah.
We've talked about that these cases involve experts from both sides that are probably very familiar to each of you, but how you incorporate those into the mediation, something if we could just touch on, and then I'd like to head into those settlement terms and confidentiality that has got to be involved if we have enough time. But can you speak to that? Perhaps, Mike, I'll let you go first on those experts.
On the experts, yeah, I think we kind of talked at least I think I gave my piece a little earlier so I can save some time for some of the others on this. It's kind of the way I talked about the approach to the mediation in general is, trying to make sure that, the experts are hitting the key issues in the case and give those key issues and the key testimony on it to the mediator to evaluate. I mean, that's really the key for using the experts to help clarify any of the issues that are in the case and making sure it doesn't do any good to supply a bunch of expert opinions that aren't the real game changers in the case, right? You really want to hit the ones that are key to your client and try to focus on those.
Jamie?
Yeah, I concur with what Mike said. And certainly, we never bring experts to a mediation.
Right.
That would be unheard of. But oftentimes mediation occurs after expert reports have been exchanged, or one side has provided expert reports, usually the plaintiff, and a summary of the key points from the expert that establish a deviation from, let's say, the standards of industry practice, or a deviation from a federal aviation regulation, and also, key the causation. An expert opinion that bridges the gap between, the failures, the omissions, and the actual happening of the crash itself. I think is very, very important.
Brad, could you help us as we have just a couple minutes left on the settlement terms and inclusion of confidentiality?
Oh, sure. A lot of times there's a focus on just monetary payment as a basis of settlement. And I think the idea here is, do we consider perhaps some ways to resolve a matter that may either not include payment of money or things other than the payment of money, or in conjunction with monetary payments? These are things like, is there perhaps in the case of an operator, is there going to be a change in their operating standards or the way they do business? Sometimes that's very important to a claimant, to not just to recover the money, but to know that they've made a difference into how the world's going to operate going forward. Is there, and here I see the slide up, are there going to be some improvements in safety that may help other folks in the future? Will there be public statements? Will there be confidentiality? Conversely, many times an institutional party may want to settle a case, but may be interested in confidentiality as well. because they may feel strongly that that they don't have a fault there, but they may want to resolve a case for business reasons or for other reasons.
Knowing we've really run out of time, but Mike, do you wish to touch upon that confidentiality? I know that's important on the defense side.
Yeah, I think it's important on the defense side, but I know Jamie and a lot of other plaintiffs' lawyers who, look, some plaintiffs' lawyers don't want any confidentiality, and I'd be interested in hearing from Brad and from Rod on how they deal with that. But I found for the most part that a lot of the plaintiffs don't want settlement stuff published either, particularly if it's a higher number or even a lower number. They don't want that publicity out of fear that it leads to all sorts of people online that are investigating their assets and finances and all the calls that come with it. And Jamie can talk about that better than I can, but I think confidentiality is a pretty important part for at least most of our clients.
Jamie, you agree with that?
I couldn't agree more. Clients want, privacy protection. They don't really want family that they may be, not close with anymore, or friends or neighbors to know that they've come into a certain level of money. It just doesn't serve any purpose. And so, over the course of my 40 plus career, I always recommend it to the clients. The only caveat is there are some jurisdictions where confidentiality provisions are contrary to public policy, and the states don't allow them. But also, if it's a wrongful death case, more often than not, you have to go to, like in Ohio, for example, you have to go to probate court and get approval. And probate court records are generally a public record. So unless the probate court judge agrees to put the settlement application in order under seal, it's very hard to keep it confidential. But me personally, I don't go out looking for the publicity, and neither do I recommend my clients. But there are lawyers who have a contrary view.
Well, listen, I can't thank you all enough. We've run out of time. Kathy, do you want to take over with regard to credits for
Yes,
what
so
we've
sorry
done?
to interrupt the
That's
conversation.
okay.
It's been really great. If you're a Florida attorney, please jot down the Florida Bar Course number so that you can post your CLE credit online. It is 2601452, N as in Nancy. That's 2601452, N as in Nancy. Credit is also available in Illinois, Ohio, and Alabama. Please see your follow-up email on Friday for more information. And we are building our webinar schedule for the coming months. Next, we'll have Complexities of Trucking Mediations with John Marion and Bo Johnson on April 22nd. Please watch your email inbox for news about our future programs. On this slide, you'll see contact information for our presenters and technical assistants. Thank you so much.
Thanks,
Appreciate it, everybody.
Thank you.
Thanks, guys.
Thank you, everyone.
Absolutely. You got it.
All right.